Just let me know when you're ready. Here.
Good morning. We'd like to welcome everyone to the May session of the Supreme Court. In light of the current public health situation, we're conducting this session remotely. The court felt it best to proceed in this manner, rather than canceling or postponing the session, because it is vital that courts continue to function, even in the most difficult of times. But traditionally, our court does not impose time limits on counsel, but due to the unique circumstances, we have developed a special protocol which has been forwarded to all counsel who will be presenting argument. Counsel for appellant and appellee, we each have a maximum of 20 minutes, with the first 3 minutes reserved for an opening statement, the final 2 minutes for closing remarks. We would ask counsel to keep an eye on their watches, but I will alert them at the 2-minute mark and ask them to promptly conclude. The justices who have questions will pose them in a preset order so the counsel might focus their attention on the justice asking the question. Finally, as is custom, I will briefly state the case in order to frame the issue before the court. Mr. Minner, would you please call the case?
Representing petitioners is Ms. Sarah Rose. Representing respondent is Mr. Robert.
Good morning again. The court has exercised an extraordinary form of jurisdiction to consider a challenge to a policy prohibiting the use of medical marijuana by individuals under the supervision of the Lebanon County Probation Services. Rose.
Good morning, Chief Justice and members of the court. Just want to make sure everyone can hear me before I begin.
You're fine.
Thank you. May it please the court, Sarah Rose of the ACLU of Pennsylvania for the petitioners, Melissa Gath, Ashley Bennett, and Andrew Koch. The Medical Marijuana Act is a comprehensive statutory scheme that sets forth the qualifications to use medical marijuana and grants broad protections to patients who engage in lawful use. It contains no exclusions based on criminal history or probation status. A qualified patient must meet just 3 criteria. They must be a resident of Pennsylvania who suffers from a serious medical condition and has received a certification from a state registered physician. The Act not only allows individuals who meet these requirements and obtain a medical marijuana card to lawfully use medical marijuana, but it also grants them a sweeping immunity. They cannot be subject to arrest, prosecution, or penalty in any manner, or denied any right or privilege solely for lawfully using medical marijuana. This immunity advances the General Assembly's stated interest in providing a program of access to medical marijuana while balancing the need to promote the access to the latest treatments with patient safety. Each of the petitioners in this case is a medical marijuana patient who suffers from a serious medical condition. Each has experienced substantial relief from their suffering due to the use of medical marijuana. The passage of the Medical Marijuana Act in 2016 allowed the petitioners to lawfully access a medical treatment that has significantly improved their lives. They are exactly who the legislators had in mind when they passed the act. But on September 1st, 2019, the 52nd Judicial District adopted a policy prohibiting the petitioners from using medical marijuana simply because they are on probation. The policy applies to everyone under the supervision of the Lebanon County Probation Services Department and prohibits them from using medical marijuana even if they have a medical marijuana card from the state. The Judicial District subsequently added an exception to the policy that allows patients to petition the court to establish that their use of medical marijuana is a medical necessity. This exception does not cure the fundamental conflict between the policy and the Medical Marijuana Act for two reasons. First, it inserts a requirement of medical necessity that's found nowhere in the Act. And second, strips medical marijuana patients of their immunity under the Act by subjecting them to penalties for lawfully using medical marijuana. In short, the 52nd Judicial District's policy confers a reservoir of discretion on the Lebanon County Court of Common Pleas to decide who can and cannot use medical marijuana. And it penalizes those it deems ineligible. That violates the plain and unambiguous language of the Medical Marijuana Act.
Thank you. We'll first turn to Justice Fair and ask if he might have a question.
Thank you, Chief Justice. My principal questions, I think, are for the other side, but since I have this opportunity, all of those sweeping rights granted to citizen are diminished for someone incarcerated or in this situation on probation. So there's no question that probation can set conditions of probation. You agree with that?
Yes, Your Honor, the probation can set conditions that meet the requirements of the sentencing code.
So assuming arguendo for a second, that the other side, and we don't have rebuttal, can shoehorn what's occurring here into one of the 13 conditions of probation or the catch-all conditions of probation. Can they do it?
No, Your Honor, and this is why. The Medical Marijuana Act, by granting that sweeping immunity to medical marijuana patients, takes the decision about whether an individual can use medical marijuana out of the control of sentencing courts, which are constrained by the sentencing code. And of course, the sentencing code is a penal statute that must be strictly construed.
So I'm sorry, go ahead and finish.
And therefore, you have to read both the sentencing code and the Medical Marijuana Act together. And when you read them together, any probation conditions that fall under the catch-all provision, you have to be reasonably related to the rehabilitation of the defendant. And they can't violate other laws that the Commonwealth, the General Assembly has adopted. And here, any condition that would allow the sentencing court to decide who can use medical marijuana, which a decision legislature has already made, and penalize people who use medical marijuana in violation of a probation condition, violates the Medical Marijuana Act and is invalid probation condition.
So and I didn't mean to interrupt you before, but you're almost arguing a conflict preemption or an express preemption. Is that fair?
I think it's a similar idea. I think that if you look at, for example, this court's decision in Commonwealth versus Wilson, where there was a statute that limited the searches that could be carried out by probation officers, this court held that that statute would require reasonable suspicion for searches of probationers, constraining the trial court's ability to impose a probation condition that allowed warrantless, suspicionless searches. And I think the same is true with respect to the Medical Marijuana Act.
Okay. Thank you, Chief Justice.
Justice Todd.
Thank you, Chief Justice. Attorney Rose, would you distinguish between this situation involving medical marijuana and individuals who may be in our Commonwealth's drug courts or DUI courts or vet courts with the use of alcohol? Because as you know, many of these individuals, while drinking is certainly legal, many of these individuals are not permitted to drink while they're under the auspices of the drug courts, etc., while they're actually on probation.
Yeah, I absolutely would distinguish alcohol from medical marijuana. We do not have a statute that grants a sweeping immunity to people who use alcohol. We do for medical marijuana. And that's for an important reason, which is that the General Assembly was carving medical marijuana out of the Controlled Substances Act to ensure that people would have access to it. Of course, it was stigmatized, and I think that that's why the immunity is necessary, to ensure that people are able to use a medical treatment that has been recognized by the General Assembly and by experts in the field as conferring a medical benefit on people who with certain medical conditions. And so medical marijuana is very different from alcohol in the sense that it's both protected by statute specifically, and it is a medical treatment that is recommended by a doctor, and it's part of a program that is subject to sweeping and strict and exhaustive regulation by the state.
Would you agree, though, Ms. Rose, that if an individual is permitted to use marijuana, medical marijuana, while on probation or while subject to the restrictions of a drug court, that they still must comply with other restrictions, such as they can't drive while they're under the influence of it and the like?
Yes, Your Honor. Trial courts are certainly within their discretion to require that individuals on probation comply with the Medical Marijuana Act. They can require that they they produce a card, the certification from their doctor, receipts from purchases. There's lots of things that trial courts can do to ensure that an individual is complying with the act. What the trial court cannot do is prohibit individuals from doing something the legislature has specifically allowed them to do, and not only allowed them to do, but granted them these broad protections to ensure that they are able to access this medical treatment.
Thank you.
Justice Donahue.
Good morning, Chief. Thank you. Good morning, Counsel.
Right.
Counsel, I'd like you to focus on the legislature's use of the phrase solely for the use of medical marijuana. And if you can, explain to me your view of that phrase in the context of, take, for example, an arrest for reckless driving. Defendant is arrested for reckless driving, and at the time, he was under the influence of medical marijuana. What's the consequences in that circumstance of the legislature's use of the phrase cannot be prosecuted or arrested solely for the use of medical marijuana?
Well, Your Honor, certainly under that situation, an individual could be arrested for reckless driving.
Right.
This immunity does not protect people from violations of other parts of the criminal code. It just prevents people from being essentially retaliated against solely because they are availing themselves of this medical treatment that is not permissible under the law. And that's the only immunity it grants, not anything else that would, otherwise subject them to arrest or prosecution or the loss of any right or privilege.
So that then would be your response to your opposing counsel's argument that this is not solely for the use of medical marijuana. This is somebody who is using marijuana and is on probation. Different context than
yeah, absolutely, Your Honor. I think that if you follow the logic of the respondent, then anyone who uses medical marijuana could be subject to arrest, prosecution of the right or the loss of any right or privilege, because if you're a teacher, the school district could say, well, you're not just being penalized because you use medical marijuana, we're firing you because you're also a teacher. Like, that was not the intent of the legislature. The legislature intended to protect people from retaliation for using medical marijuana consistent with the law.
Thank you.
Justice Doherty.
Thanks, Chief. I want to follow up from what Justice Donahue just indicated. For example, under the license area, going back to the word solely, the statute specifically says solely for the use of medical marijuana. But how do you get around the fact that it's not solely that the underlying offense, the criminal conviction, is the basis for the imposition of any restrictions of his or her freedom, not the use of marijuana in and of itself as per the intent of the General Assembly? How do you distinguish that?
So I think that goes back to a point that I made previously, which is that the fact that the person is on probation does not allow the sentencing court the discretion to prevent them from using medical marijuana, because the sentencing court is constrained both by the sentencing code's catch-all provision, which requires it be reasonably related to rehabilitation, but also by the Medical Marijuana Act itself, which prohibits an individual from being subject to arrest, prosecution, penalty in any manner, denied any right or privilege solely for the use of medical marijuana. So here, if the person were on probation and we're following every single condition except the medical marijuana condition, and as a result their probation were revoked, it would be revoked solely because they're using medical marijuana. And that is what the legislature tried to prevent by passing the statute.
Thank you.
Justice Wecht.
Thank you, Chief Justice. Good morning, Council. Suppose probation court had circumstances before it where the holder of a probationer with a medical marijuana card appeared to be abusing that privilege or using that privilege for purposes which ran afoul of the probation court's supervision. What recourse would the judge have?
So the judge would be able to impose any penalty that they would otherwise have under the sentencing code for someone who violated a probation condition. If one of the conditions of your probation is you have to comply with the Medical Marijuana Act, and if the judge has evidence that you're not complying with that, then you can be subject to a penalty as a result. In addition, the Medical Marijuana Act itself, in addition to setting out certain distinct violations, makes any violation of the Act a misdemeanor. So, the courts have implied discretion to require people to comply with state laws. So if somebody's violating the Medical Marijuana Act, then they're committing a crime, and that would also give the court a basis to impose penalties. But the important thing here is as long as the person on probation is complying with the Medical Marijuana Act, then the trial court does not have discretion to penalize them or revoke their probation.
And just a quick follow-up with respect to that compliance. How do you see the hearing before the judge differing from whatever threshold showing is needed to get the card in the first place?
Are you asking about the hearing that's contemplated by the policy?
Correct.
Yes, so the hearing that the policy contemplates, one, it puts the burden on the person on court supervision to establish, to the court's satisfaction that medical marijuana is a medical necessity. Medical necessity is very different from what an individual has to establish to obtain a medical marijuana card. They have to get a doctor to certify that they have one of the 23 listed serious medical conditions under the statute and under the regulations, and the doctor has to indicate that the individual would, may receive some benefit, palliative or medical benefit from the use of medical marijuana. That is a far lower threshold than I think the typical understanding of medical necessity, which is typically something of last resort. But one of the problems with the policy is it doesn't explain what a person has to show in order to prove medical necessity. It's incredibly vague, and I think it deters, even if that exception is available, I think the fact that the individual bears the burden of proving to the court that they have a medical necessity deters people from even engaging in that process.
Thank you.
I'm going to ask Justice Mundy if she has a question, and if she does, if you would please respond to that question and then conclude your argument. Justice Mundy.
Sorry, I have no questions. Thank you, Chief.
I appreciate it. Would you briefly summarize your argument, please?
The Medical Marijuana Act comprehensively establishes the qualifications to use medical marijuana and the protection for patients who engage in lawful use. By adopting a policy that allows the court of common pleas to decide who qualifies as a medical marijuana patient and to impose penalties on people who use medical marijuana lawfully, the 52nd Judicial District violates the Medical Marijuana Act. The policy should be declared illegal, and the Judicial District should be permanently enjoined from enforcement. Thank you.
Thank you, Ms. Rose. We'll hear from the respondent.
Thank you, Mr. Chief Justice and Associate Justices of the Court. May it please the Court, I'm Robert Crandall with the AOPC Legal Department, and we represent the 52nd Judicial District. The chief problem with petitioners' arguments is that what they've done here is they've reduced everything about their lives and what good citizenship entails to their medical marijuana prescriptions. And then what they do is they essentially argue that, well, judges aren't doctors and no one can interfere with the medical marijuana prescriptions. I think petitioners' counsel kept referring in her argument to this sweeping immunity and that the medical marijuana law permits. And what they've essentially done is they've claimed that the medical marijuana law has essentially built an entire wall around this part of their life, such that a probation, in the probation context, the courts could never, under any circumstances, evaluate what's going on with their health. But here's the thing. A person's health or their medical necessities is not just some matter of private concern. What my doctor prescribes me is not just a private concern, it's state regulated. And that's for my safety and for the safety of others around me. Prescribing medications to any one person has effect on a society at large. That's why the practice of medicine is so highly regulated. So this argument from the petitioners that says that the medical marijuana law somehow changes that landscape and reduces everything about their lives and getting out of the criminal justice system as to just simply relating to their personal health care is just simply not correct. The law is not written that broadly. What's going on right now in their lives for the petitioners is that they are all on a path to back to good citizenship. The court is focused on trying to get them rehabilitated. And what their doctors are describing them as one part of that equation. And the doctors should be totally focused on their health. That's one part of their lives. But that's not the only criteria here for good citizenship. Their health is not the only criteria. If it were, if you think about it, athletes would be good citizens if health was the only thing that a probation court has to consider. But a fully formed citizen and a good citizen, not only makes good healthcare decisions, they follow all the laws. And the courts are charged with a greater responsibility than just doctors. The courts have to ensure that these petitioners get out of the criminal justice system and are rehabilitated, and they live good lives and become good citizens. So because they have claimed that their health and the medical marijuana law has all this sweeping immunity, they've created a lot of confusing and contradictory arguments. The first one is that the medical marijuana law created some sweeping immunity. And if we look at the law, we see that it doesn't. And nowhere does it say that. In fact, if you go just to the very beginning of the law, in section 102, in the Declaration of Policy, the General Assembly is I think in a sense, timidly moving medical marijuana.
Mr. Crandall, sorry to interrupt you, but we've asked you to limit your opening statement to 3 minutes, and you've exceeded that. So we're going to ask Justice Bear if he has a question.
Sure. Thank you, Chief Justice. Mr. Crandall, assume hypothetically that one of your probationers has cancer and a physician says you need chemotherapy to live. Does the probation department have the right to say, we won't countenance the chemotherapy unless you can prove in a courtroom medical necessity?
No, I don't think that at all, Your Honor. I think chemotherapy is very different from marijuana. And for example, chemotherapy, as far as I'm aware, has not ever been treated as a Schedule I narcotic under state law. So
do me a favor, because my time is limited. I apologize for interrupting you, but I don't want it to run out. You're not intentionally, but you're changing my hypo. Assume that the chemo that they're giving is experimental and indeed has a Schedule I narcotic comprised within it.
Yeah, and in that case, if this individual is on probation, for example, I think the court would have to balance that, consider that with their need. And in that case, Your Honor, that's a good example. Maybe that's a situation where the court lets them, use the medical marijuana in balance. But we're
not talking medical marijuana. We're talking cancer and chemo. And your answer is that Lebanon County can prohibit chemotherapy if the chemo cocktail contains a Schedule I drug. Is that correct?
No, I don't think that's a correct statement, because what the court's doing is not just targeting only that that drug, what the court has to look at is the entire circumstances of the person's life. So, for example, is this person, in this example, are we talking about somebody who has a problem with obeying laws? Is this somebody that is a problem?
And I apologize for interrupting, but time is short here. He's on probation. I want to keep the facts of this case. He's on probation. He contracts cancer, and I'm sure that happens on occasion.
Right.
He's going to get a cocktail of drugs to suppress the cancer, hopefully, and that cocktail is going to contain a Schedule I drug. I don't know if that's outlandish or not being a physician, but just under those facts. And I think what you're saying to me, and then I'm going to yield my time back, what you're saying to me is under those circumstances, your client does indeed have a right to have a hearing to decide whether or not the chemo is necessary.
That's correct, Your Honor. That's correct.
Okay. Justice, thank you.
Thank you, Justice Barrett. Justice Todd.
Thank you, Chief Justice. Attorney Crandall, is your argument stronger in instances where the probation is as a result of a substance abuse crime?
I think that's probably a fair assessment, that substance abuse is probably more what this is targeted to. And the policy itself, if you check out the policy actually draws this connection between substance abuse and crime. So I think that substance abuse is something that is on the court's mind, and the connection between substance abuse and crime is sort of laid out in the district's concerns. In the opening part of its policy, it lays that out. And all three of the probationers here have that. They share that in common in each of their situations. Illegal possession was some component for each of these probationers.
The problem I'm having is we're not going to decide this case just for these three probationers. We're going to decide the case for Pennsylvania as a whole. And many probationers are not affiliated with any drug problem. Now, I agree with you, a lot are, but some are DUI, no drugs, some are theft, some may be domestic violence. There could be a whole host of criminal infractions that did not involve drug abuse or substance abuse. So I guess that's what I'm asking. Is there a distinction in your mind between the type of crime that gave rise to the probation and the medical marijuana use?
Yeah, Your Honor, I think that could be the case. But I think for all these probationers, let's say if a probationer has no connection to substance abuse and they want to use medical marijuana, then they would use the policy and they would petition the judge and say, Your Honor, look, my crime has no connection to substance abuse. I've never had a history of substance abuse. Please relieve me from this general condition. And I think, that's something the judge would have to consider.
Thank you.
Thank you, Justice Donahue.
Counsel, I'd like to follow up on your last answer to Justice Todd. What you described as how a probationer could get out from under the burden being imposed by this policy is not what I understand the policy to be. My understanding is that a probationer would have to prove medical necessity. And I'm not certain exactly what that entails, other than bringing in a physician who was the authorizing physician, who met all of the protocols under the statute. Is that how the judicial district intends for this to work?
No, Your Honor, I don't think so. I don't think it's that defined. But part of the problem with the I can't really give you a solid answer on that because we haven't seen the policy implemented yet. Because of the posture of this case, by coming here on King's Bench jurisdiction, we just simply have no record to say how the judges of the 52nd Judicial District would look at that phrase, medical necessity. I don't think it would be that.
Counsel, I mean, if the district cannot tell a probationer what he or she has to establish. Isn't that on its face enough to say this policy can't stand? I mean, if that is a moving target, then under what circumstance could anyone ever attempt to meet the standard? If it's totally up to the unbridled discretion of the probation judge to decide whether or not the standard has been met.
The medical necessity component of it, though, if you think about it, I don't think just following the medical marijuana law that it's hard to get to what medical necessity would be for them. I think they've done a good job in this case of laying out in their petitions their circumstances. They laid that out, and they only took a couple of pages in their petitions to lay it out. Now, would that meet the standard for what the judge would say is acceptable medical necessity? I think the problem here would be just looking at what they've laid out only as what they've laid out and not considering all the other parts of their life as well. So they've done a good job of laying out, I think, a convincing argument for why they may need exceptions to the policy. But what the judge is not considering is not just the medical necessity. He's also in probation considering all the other factors of their life in a very, kind of holistic way. So I see what Your Honor is saying by looking at medical necessity and saying, what does that phrase mean? But I'll just have to go back to my answer before, is that, well, first of all, it seems to be apparent based on what they laid out. They laid out some medical necessity in their brief, and second of all, we just would have to see what the district does before we rule on that.
Thank you, Justice Dougherty.
Thanks. So, a follow-up, piggybacking on Justice Donahue's concerns. In the policy, it specifically indicates that the burden is on the petitioner. Yet, in your brief, you liken this to a violation hearing. In a violation of probation hearing, the burden's on the Commonwealth. What causes this shift in burden, and why should the defendant be the one when, in fact, this is a encumbrance of the Commonwealth?
Yes, Your Honor. The reason, I think, if you go back to the first page of the policy, the concerns that the court expresses on the first page sort of explain that on the second page, why the medical necessity burden would be on the petitioners. The court lays out concerns on the first page that are very consistent with the General Assembly's Section 102 declaration in this act. The General Assembly talks about how this, medical marijuana might be something that is going to help patients. It suggests that medical marijuana is something that may mitigate suffering in some patients. And the court then follows that up with the first part of the policy on the first page that talks about how, look, medical marijuana is in this flux at the moment. It's in an evolutionary stage where the federal government thinks that it's still a Schedule I narcotic. It's got high potential for abuse and dependency. And that, I think, then fuels the second page, Your Honor, when you get to there, is why the petitioner would need to come forward with a little bit of evidence as to what's going on in their life and their circumstances.
Why would that not be collected in a pre-sentence investigation? Post-conviction, pre-sentencing.
As to why that would not be collected in the sentencing process post-conviction?
Correct. In a post-sentence investigation, why would that information not be collected then?
Well, that information very well could be, and maybe that's what the petitioners rely on. Maybe they just simply say, look, Your Honor, here's my post-sentencing conviction, report. Here's everything that in my life. Those are very good reports, Your Honor, as you point out. They go into a lot of things, and maybe that's what they rely on. Maybe that becomes a very easy way to help establish the medical necessity. But I think what the court's trying to do is it's trying to go a little bit further just to, not redetermine their medical necessity, but verify what's going on with their medical marijuana use.
And if I may, one more question. Can I ask one more question, Chief, quickly?
Oh, sure. And then we're going to...
Sure. Real quickly. Medical necessity is a specific term of art which requires expert testimony. Why are you now imposing an additional burden on the defendant when you say he or she now bears the burden of medical necessity proof?
Well, again, I'm not sure that the policy is using the legal terminology of medical necessity. I don't think it's going for that. I think looking back to the first page of the policy shows you, I think, what the court's concerns are. I don't think it's using the legal term. But again, we just don't have any record to make that prediction on at this point, one way or the other. I don't think the court could say that that's what the policy is saying because the record is so thin at this point.
Thank you.
Justice Wecht.
Thank you, Chief Justice. Good morning, counsel. About 9 years ago, this court in Wilson said that a court can't create probation conditions that differ with statutory requirements. How is this case any different? What is it about the no penalty clause of the statute that is ambiguous?
Yes, Justice Wecht. I think the no penalty clause, the first thing you have to do with that no penalty clause, it's section 2103. The first thing you need to establish is that, probation isn't a right or a privilege in the sense that I think the statute's using it as. The right or the privilege for all of these individuals is to be free from searches and seizures, to have free speech, all the rights that we enjoy as citizens who aren't on probation. So what the question then becomes is, can a court lawfully look at their use of medical marijuana and deny them some right or privilege solely for the medical marijuana? And that's our argument is that there's nothing in conflict with the medical marijuana statute because they're not being interfered with solely because of their medical marijuana. They are at this moment, their rights and privileges to be free, to stay out after 11, to have pagers and cell phones and other things, those rights are being infringed because they're already on probation. That's why there seems to be no conflict here with the Medical Marijuana Act and in this probation policy.
Wouldn't the policy that Lebanon County has crafted set up the potential for repeated conflicts with the statute, given that the judges there could, in theory, enter medical non-necessity judgments in each and every case where a physician acting under the statute has already made the judgment of eligibility for the card that the legislature addressed?
I don't know, Your Honor, but I think this may help answer the question, is that, just having the card is that's not the equation of lawful use. Lawful use under the Act is something different. And if they are verifying the card, if they are verifying how they're using the prescription, then I don't think there's any kind of interference with what in Your Honor's example there.
Thank you. Justice Mundy?
I have no questions, Your Honor.
Okay. Do you have a very, very brief summation, Mr. Crandall?
Yes, I'll just be brief in my closing here. The policy in this case really mirrors the declaration of policy that comes out of the Medical Marijuana Act itself. It's in section 102. The policy recognizes that medical marijuana is not settled science. The policy recognizes that patient safety is a chief concern. And the General Assembly agrees with all this in section 102. The policy recognizes there's a potential connection between criminal violations and substance abuse. And again, I don't think the General Assembly disagrees with this because marijuana is just not prescribed like any other drug. I don't get a license for my back pain prescription, for example. Now, if the court wants to offer its input, I think, and guidance to the districts on how to implement these policies and help steer the policy, I think that's a reasonable approach rather than throwing the whole policy out like the petitioners have advanced here. Thank you for hearing me today.
Thank you. That concludes the argument in the first case. We'll commence the argument in the next case in 5 minutes. Brian, you can get counsel ready for the next case. We ready?
Okay, the next argument is Commonwealth of Pennsylvania versus Beth Ann Mason. Arguing for appellant is Jonathan C. Faust. Arguing for appellee is David Earhart.
Good morning. This appeal concerns the Pennsylvania Wiretap Act and the admissibility of the footage captured by a hidden camera that was stored in a child's bedroom for purposes of monitoring the children's babysitter. You can begin your argument, please, Mr. Faust.
Thank you, Your Honor. May it please the court. I'm Chief Deputy District Attorney Jonathan Faust on behalf of the Commonwealth. The issues in this before the court, there are two of them. They are both of first impression in this Commonwealth. The first being that whether Ms. Mason had a reasonable expectation of privacy in the child sleeping in. And the second, whether the sounds that came from her forcibly slamming the child into her crib and then going back to the child, whether those sounds are covered under the Pennsylvania Wiretap Act. With respect to the first issue, Your Honors, I believe that the lower courts erred in that they specifically found, number one, that Ms. Mason had a subjective expectation of privacy where she had the opportunity, she did take the stand, and she did not say, I believe that I was not being filmed. I believe that I was in private in my employer's home. There was also other subjective factors, such as the valet family continued to question her regarding suspected child abuse, where she could not come up with any answers. The second prong of my analysis with respect to that, to the second element, whether there's an expectation of privacy and whether it's reasonable, is that the lower courts erred in finding that society and the court as a whole is actually ready to recognize this type of claimed privacy right as reasonable in Pennsylvania. This court, nor society as a whole, should be ready to do so. With respect to the second issue, Your Honor, the sounds that coming from a child being forcibly thrown into a crib and then being beaten are not sounds that were contemplated oral communications by the Wiretap Act when it was enacted by the legislature. I certainly understand the argument that you can have the sounds are differentiable from the specific words that Ms. Mason in the child's face to start with. And then afterwards, she was talking to the child about sleeping so that essentially no further beating would occur. I believe that those sounds from the child being forcibly thrown and the sounds of her being beaten can be separated enough from
Well, I think we've lost, for some reason, Mr. Faust. So keep the case moving. We're going, and perhaps you'll rejoin us and we'll try to adjust. But I think we'll ask Mr. Earhart, the counsel for the appellee. Are you back, Mr. Faust, now? Can you hear me, Mr. Earhart?
Yes, sir.
Would you please begin your argument?
Yes, thank you. Good morning. My name is David Earhart. I'm with Steve Rice.
Yes, Your Honor. I appear to be in communication.
Well, we'll give you a little try again, Mr. Faust. But if we can't get this squared away, you're trying there. Yeah, he's disappeared from the screen. So go ahead, Mr. Earhart.
Thank you, sir. I'll move forward on behalf of Beth Mason, of course. Certainly, I don't want to reiterate my entire brief. I'm confident that the court has reviewed it. A couple points though that I'd like to make. First, the Commonwealth in its brief is fairly dismissive of the persuasive authority, at least what I hope is persuasive authority, cited by the Superior Court from our sister states. And it seems as though the basis of that dismissal is that those cases that deal specifically with babysitters and their expectation of privacy are in the context of government searches and an expectation of privacy from government searches. I would submit that authority should still be considered persuasive. In fact, perhaps even more so under the circumstances here when we are talking about clandestine recordings from a private actor. I think it's reasonable to think that a person will have, a person who is suspected of wrongdoing even perhaps, is going to have a heightened level of sense of privacy when they're dealing with a private actor, a friend, a family member, or even an employer. Granted, an employer is not always a friend or family member, of course, but they are certainly not always a government entity. And I believe the idea of someone having to be concerned about their privacy is at its peak when they're dealing with law enforcement. Someone with a secret would be much more inclined to tell that secret to a friend or a family member or an employer, all before they would be so inclined to reveal it to a government actor. So I do ask the court to consider that same authority that the Superior Court seemed to find informative and persuasive. The next fact, I promise I won't linger on it because I do address it in my...
We're not going to linger too long at all because you had a brief opening and we're going to turn to questions.
Certainly.
So I'm going to ask Justice Todd if she has any questions.
Thank you, Chief Justice. I do. Good morning,
Good morning.
Counsel. It seems to me that this case, as Judge Piniella on the Superior Court opined, that this case really comes down to whether your client had a reasonable expectation of privacy in the home that she was working, and specifically in the children's bedrooms. And I have a hard time understanding how she would have such a reasonable expectation of privacy in the bedrooms where the children slept. Now, there's no indication that she was an overnight employee, that she was a nanny with her own room. If she was a stay-over nanny who had her own bedroom and bathroom, certainly. I have no contest there with her expectation of privacy. But with respect to the children's sleeping rooms, I cannot fathom how she would have a reasonable expectation of privacy, and I'd like to give you the opportunity to dissuade me of that notion.
Certainly. So if I can begin, I just want to make sure that I advocate for what I believe is on the record. The reason that the area at issue is typically described as the children's sleeping area within a bedroom is the record did not establish that the room was actually a child's bedroom exclusively. The setup was that the bed the nanny cam, for lack of a better term, was placed on a larger bed in the bedroom and facing the child's crib. Now, that point may not be moving to some people, but to me, I do think it makes a bit of a difference in that it is not a room exclusively used for the children. There would be adults that would be traversing in and out of the bedroom at any point.
But there was no, Counsel, there was no record evidence that the nanny slept on the bed in that room, is there?
Oh, I agree with that. That's correct. But what I would say, Your Honor, is this. This is a home and this is a place of employment. A home is traditionally thought of a bastion of privacy. Now, it was not my client's home, of course, but that does not change the fact that it is a residence and it is not a place traditionally thought to have clandestine surveillance. It was her place of employment, and certainly there are some places of employment that will overtly inform their employees that they are being recorded. Of course, it's no longer then secretly recorded. And my position may just be one that I differ on the current state of society, which is that I don't think it's reasonable for a person who has arguably gained the trust of the family, so much so that she's remained their employee for several months. She takes care of the children all day into the evening, 3 young children. I do not think that the ideas are congruent that she would believe she had such a high level of trust from the parents/employers, but also suspect that perhaps they were secretly recording her.
Thank
So,
you, Mr. Earhart.
Justice Donahue.
Counsel, your client did not testify that she believed she had an expectation of privacy. And I'm going to anticipate your answer. You're going to say, well, she could rely on circumstantial evidence. But for every argument that you just made as to why she did have an expectation of privacy, this record is full of bits and pieces of information that would suggest otherwise. She was questioned by the father about whether or not she physically abused the children. That in and of itself, would raise a different set of issues from those that you set forth. So is it critical in this circumstance that your client had testified that she had an expectation of privacy?
well, of course, my answer is no. I don't believe that that's the case.
But why not?
So I don't believe the law requires her to take the stand and say the magic words, because anyone could do that, whether reasonable or not. I do think it would have bolstered our position. I won't argue that it wouldn't have had she gotten on the stand and made that statement. However, the fact that she hasn't actually articulated that, I don't believe that's fatal to our case. The idea that we really hope the court understands is the confrontation about the children having bruises. The record, the Commonwealth suggests that and argues that almost as though it's the gospel truth. However, it is not uncommon for parents to have a discussion with a babysitter about where marks on children are coming from. As I'm guessing many, if not all of you know, young children oftentimes do find themselves with marks and bruises just based on their daily activity. So it's not uncommon for mom or dad to come home at the end of the day and say, oh, why is this mark here or this mark there? And, the fact that my client couldn't explain it doesn't mean that she failed a confrontation about her suspected child abuse. And I would suggest the fact that she remained employed by these people for 2 months beyond this discussion of the marks suggests that the family really didn't confront her about child abuse specifically and then receive unsatisfactory answers. They continued to keep her in that position for a very significant amount of time. So I do think that from my client's perspective, she would have thought that there were no issues, that if that even was an issue in the first place, it had been smoothed over or that the parents had gotten beyond it.
She did testify, did she not?
Very briefly, yes.
But she didn't testify that she had an expectation of privacy.
She did not say that. That's correct.
Okay. Thank you.
Justice Dougherty.
Counsel, there is a conflict between you and the Commonwealth. Do you agree that the father terminated her employment after he observed the video?
Sir, I don't want to speak out of turn. I will admit, I do. First of all, I do know that took place, but I can't speak to where exactly that is on the record, if at all. But I do know that my client was terminated afterwards.
The Commonwealth references in their brief that the father, after observing the video, terminates her. Does that not presuppose that she knew she was being observed such that she manipulated it, such that she has no expectation of privacy?
I don't think it does. One factual difference that I think maybe vehemently argued is the record does not establish when my client, if at all, became aware of the fact she was actually being recorded with the, again, I'll say nanny cam. There is testimony that at some point she looked into it, maybe put a flashlight in it and shook it around. I would suggest that means she certainly did not know it was there at the time of the incident issue, and would also suggest that the trial court made a factual finding that that evidence was not established. She was aware of the presence of the nanny cam before the incident at issue. As to the exact time of her termination, sir, I can't speak to, and I apologize for that deficiency. But I don't read the time of her termination to be very meaningful to the argument that we're having today.
Fair enough. Thank you.
Justice Weck.
Thank you, Chief Justice. Counsel, good morning.
Good morning.
Why are the nonverbal sounds, the hitting, slapping, etc., why are those an oral communication, given that the statute defines communication as something uttered?
So when we look at the statute, it talks about any electronic communication. It also uses generally the term content. And it also talks about the exclusion of any evidence that is derived from an oral communication. And I think that it's meaningful for the same reason, the same argument that the Commonwealth wants those noises to be heard. And what I can almost promise you is what they're going to argue at trial is the context of the oral statements make the non-verbal or non-oral statements very meaningful. And I think you can derive from the sounds what's being said by the defendant. So the problem is, if you eliminate the verbal or oral communications here and you leave the other sounds in, the evidence that the jury can glean from the other sounds is still there. And that's, again, that's probably why the issue is before you right now. The Commonwealth is acknowledging there's value in those sounds, as does the statute. So,
I'm sorry to interrupt, just testing your point. Suppose that not a single word was uttered. Suppose the audio consisted only of the sounds. What would your position be?
So I still would suggest, sir, that evidence can be derived from the sounds in that secret recording. I do not believe that we are asking the court to say there must be a nexus between an oral statement and the other non-oral sounds. However, in this particular case, the context is what is meaningful. And I can throw some other examples out there where context would be meaningful in these scenarios, but I think the point is probably made. So, you know, the overall sound has incredible value, and I would assume the Commonwealth would acknowledge that as well.
Thank you.
Thank you, Justice Mundy. Thank you, Justice Mundy.
Hey. Hello. I'm not sure what the record reflects on the status of your client. Was she an overnight babysitter? Did she have a bedroom in this residence?
She did not and was not. She was there oftentimes from very early in the morning through sometimes later in the evening. Both of the children's parents were employed, and she would spend quite a significant amount of time there. Not an overnight guest, though. At least I don't believe the record reflects on any regular basis, if at all. So,
well, isn't the value of the cases that you've cited from Texas and Connecticut mitigated somewhat by the fact that both of those cases involved babysitters who, in fact, had bedrooms in the homes and stayed overnight?
I think it is. I'll concede that it is. And it goes to the point I made earlier. I certainly would be inconsistent if I didn't agree that it's diminished. But it is a residence, and it is a bit of a hybrid facility, being a residence and a place of employment.
That's all I have. Thank you.
Justice Bear.
Good morning, Counsel.
Good morning.
Why do they call them nanny camps?
Well, Judge, I think that they, or excuse me, Justice, I think that they, when they came to light, this home surveillance, these cameras made a bit of a splash. This is speculation on my part, of course. But I think when they first came to light, they were hidden in teddy bears. They did come into the popular culture consciousness because of the idea that these were clandestine recordings. Certainly, home surveillance was not a shocking new idea. The appropriateness or the prevalence of home surveillance, I guess, is another issue.
But may I interrupt you? Given, and I think I agree with you, given the prevalence, a prevalence to such an extent that we have within the last 10 years, I would guess, given a name to these. I'm with Justice Todd. It seems to me that I would have an expectation that I am on camera. I would expect there is a nanny cam. I would question a parent who doesn't have a nanny cam. So it seems to me that your client's argument here that she has an expectation of privacy is belied by the societal norm of nanny cams. Now, what am I missing?
Well, Judge, I actually think that the idea that they are such a known entity kind of speaks to the notion that they are something special that people do not necessarily accept. We don't hear about any other type of camera, and there's nothing offensive to me about a person recording a babysitter or nanny. It's the secret surveillance here that is problematic. This is what I believe the statute is seeking.
Although, counsel, one would assume if they put the camera up in the corner of the room and it was pointed at her, she would perhaps hit the baby somewhere else, to the left or right of the camera scope.
Or hopefully that would not be the intent of the people installing the internal surveillance. Hopefully they wouldn't make that assumption. But what I think the real function of it would be, if they were to put it in public view or do her the common courtesy of notifying her that they were secretly recording her, what I think that it would do is what I think the function of most surveillance is. It would have a deterrent effect.
Right. Let me ask you one more question, if I may, because our time is short given the structure of this. And of course, we write, as you know, for all of Pennsylvania, for all scenarios. If you prevail here, doesn't that give license? Isn't the law of Pennsylvania that an invited guest, assume a licensee, in a home can go through a medicine chest, an underwear drawer, anything else, and to the extent it's picked up on a closed circuit camera, and that's the evidence of it, it can't get into evidence?
No, sir. I mean, I think the court has already clearly ruled that the video comes in. So I do think, to the extent that you're concerned about privacy concerns in a home, there would be video surveillance that is admissible. And my concerns actually...
Go ahead. No, that's a good point. I appreciate it.
My concerns actually go the other way, which is to say, are the floodgates going to be opened in places of employment to clandestine audio recording? Can I walk into the district attorney's office and record my conversations with them when I'm sitting in their room? Can my employer audio record my conversations at my desk with my staff or with my clients? Can someone come into your offices and record what you're saying? The idea that the slippery slope exists is real because of the prevalence of this recording equipment. You can go on Amazon right now and buy a pen recorder for $50.
And I understand your point. I would suggest in conclusion that there's distinction, as Justice Todd said and as I began, between the nanny cam and the pen recorder. But thank you for a good answer.
Mr. Earhart, our time is up, but you if you had just a sentence or two by way of summation, if not, we'll conclude the argument.
Thank you, sir. Just to flesh out my last point, it is a real concern in society right now what, if any, privacy we have as citizens. And I do understand that the old adage, sometimes bad facts make bad law. And I would agree the facts of this case are certainly not wonderful for the defense. That having been said, there are so many different variations of this fact pattern that would be harmful to the fabric of society. Just moving the secret recording from a children's sleeping area into the bathroom or into an area where a cell phone is typically used would have monumental complications. I do understand that those are not the facts of this case. I am concerned about that door being open and our rights as citizens being diminished even further than they are now. I thank you for your time and consideration.
Thank you. Could we see where we are with Mr. Faust, the attorney for the appellant? Can you hear us, Mr. Faust?
I can hear you, Your Honor.
Okay, when we encountered the technical difficulties, you had started your argument, so we've heard from the appellee, and I think you've had a chance to open your argument, so we do understand your argument because obviously, as always, we have briefs from both parties, and we wanted to give you a chance to respond to any questions the court might have. So we're going to see if, starting with Justice Todd, if she had a question.
I have no questions, Chief Justice.
Thank you. Justice Donahue?
Yes, counsel, are you asking us to adopt a black letter rule in the circumstance involving oral communications that take place within a child's bedroom?
No, Your Honor. I'm not asking certainly for a bright line rule or anything like that. I believe the case law coming out of this Supreme Court in the past as it relates to rights of privacy in the area of searches and wiretap violations specifically say that it should be based on a case-by-case basis.
Okay, so you disagree with Judge
That's what I'm advocating.
You disagree with Judge Pinella, who took the position that anyone who's in a child's bedroom has no expectation of privacy in that context.
I wouldn't say that I necessarily disagree with that, but I certainly understand the court's hesitancy to put a bright line rule out there.
Well, yeah, like how about a grandmother who's babysitting her grandson? Is there an expectation of privacy on the part of that grandmother in the child's bedroom?
I believe on the facts of the case, it would just depend on the facts of the case. The grandmother could be the sole caretaker, then that would be different than whether she was just a person who sees the child once a year.
Okay, so you're asking us to essentially preserve existing law where you look at the facts on a case-to-case basis.
Correct.
Thank you.
Thank you, Justice Dougherty.
No question.
Justice Wecht.
Thank you, Chief Justice. Good morning, counsel. Looking at the statute, counsel, why shouldn't we be asking whether Mason had a justified expectation that her communications were not being intercepted? Why isn't that the inquiry? Why do we care whether this nanny had a broad expectation of privacy in Vaille's house or in the child's bedroom? Doesn't this case illustrate that we ought to be thinking about the words of the statute about the expectation of interception rather than a constitutional right of privacy?
I do agree, but I believe that those two things are so intertwined together that you necessarily can't separate them apart, Your Honor.
Thank you.
Thank you, Justice Mundy.
No questions.
Justice Bear.
Just one. Following up on Justice Donahue, how important is it to this case that the father received complaints of corporal punishment from the brother, older brother, and then confronted the babysitter, arguably putting her on some notice that she was under scrutiny? Does that make any difference? Or, as I posited earlier, is the fact that we all know what a nanny cam is. We all buy them and we all have them enough.
I believe both of those facts are extremely important to this case. I believe that the general knowledge that nanny cameras are so generally accessible to the general public, we could get on Amazon or any other platform and buy one and have it here next day. But in addition to that, you then take that knowledge with the knowledge that they're already questioning you of suspected child abuse. I believe that puts it over the fact that there can be no subjective expectation of non-interception to privacy.
All right. Thank you, Chief.
Thank you. Do you have a word or two by way of summation?
Just very briefly, Your Honor, I would just ask this court to reverse the suppression court with respect to the reasonable expectation of privacy of Ms. Mason. I think it's clear that on the facts of the case, she did not have a reasonable expectation of privacy, nor should, under the facts of the case, this court be willing to find that to be societally acceptable. Secondly, Your Honor, if the court would rule against me on that specific issue, I would ask the court to permit the nonverbal, non-communication sounds from her forcibly slamming a child into a crib and then beating a child, those to be admissible because those are distinct from her work.
Thank you. Thanks to both of you. And that concludes your argument in that case. We'll stand down till 11 o'clock, in which time we'll commence argument in the third case for the day. Thank you.
Thank you.
Thank you, Your Honor.
The next argument is in re Consolidated Appeals of Chester-Upland School District. Representing the appellants is Attorney Robert Byer. Representing Appellee Chichester is Donald J. Weiss. And representing Appellee Chester-Upland is Pamela Van Blunk.
Good morning, Mr. Byer. The issue in this appeal is whether the income generated by land on which a billboard is located may be considered in the calculation of fair market value for the purposes of property tax assessment.
Good morning, Mr. Chief Justice, and may it please the court. Section 8811B4 of the Consolidated County Assessment Law unambiguously mandates no sign or sign structure primarily used to support or display a sign shall be assessed as real property. This language means that billboards are not real estate, and it precludes all three methods of assessment under Section 8842. It does not create an exception allowing the income approach. Assessing land based upon income from billboards necessarily assesses the value of the billboards, just as an income approach assessment of land with an office building assesses the value of the building. The Commonwealth Court's decision not only allows what the statute expressly prohibits, but cannot be squared with this court's decisions. In Schaefer Brewing, this court decided that the machinery and equipment exclusion in 8811B1 prohibited indirectly valuing the excluded items. And if the school districts here were correct, then this court's 2002 decision in Independent Oil and Gas Association was meaningless because the assessment could be based upon the income to the landowner from oil and gas leases, even though the oil and gas are not accessible. The Commonwealth Court's decision creates both inconsistencies within the statute and renders statutory text as surplusage. There is no textual basis to allow income approach assessments for excluded property under only Section 8811B4 and not under other subsections of 8811B. But this court in Schaefer Brewing already answered that question for machinery and equipment under B1. And if the school districts were correct, then it was wholly unnecessary for the General Assembly to craft language expressly allowing income approach assessment of land containing wind generators under subsection B5. Our position does not result in the land itself being excluded from assessment, as the school districts erroneously contend. Our position is that the land may be assessed, but the General Assembly requires that the land be valued without regard to income from a billboard on the property.
Thank you. We'll begin the questioning with Justice Donahue.
Thank you, Chief. Good morning, Mr. Byer.
Good morning.
I have to just start out by saying I disagree with you, and let me tell you why. I'm looking at this statute, the exception that we're talking about, and maybe I've just read it too many times, but it seems clear on its face that what is excluded from taxation, or what is accepted from taxation, to be more precise, is the sign or the sign structure. It does not say the sign or sign structure and the ground on which it is placed. Under your interpretation of the statute, do we not have to read that language and the ground on which it is placed or something similar to that into this exception? And isn't your argument in direct contravention of our law, including one TAC, in which we have held that ground leases need to be taken into account in the valuation of the real property held by the taxpayer?
Your Honor, the language that you're suggesting, we are not suggesting be implied into the statute. We have no problem with the land being taxed. The question is, how do you value the land? How do you assess the land? Section 8811B is an exclusion provision that says that the billboards cannot be included within that land, even though they're on the land. you would value the land. I mean, let's assume that the exclusion were not there. Let's assume that you could tax land containing a billboard. You would do it precisely the same way as the school districts are proposing here. You would have the land, you would have the billboards, you would apply an income approach to income-producing property, which is why we're saying that by excluding the billboards, the General Assembly meant to exclude these as real estate to be assessed at all. You can assess the land without assessing the income or the value of the billboards. We think that one tech case is distinguishable because that's under everything there is under 8811A. The land here is under 8811A as it was in one tech. And in one tech, the only question was whether you could include buildings within the scope of what is taxable. And buildings, of course, are also included within 8811A. So we see no conflict between that. And we think that the conflict is created when one reads the statute as a whole with respect to 8842, which tells you can assess using three methods. Income is not assessable as income. This is a real estate statute, not an income statute. So income is just another method of assessing the land. If you include the income from the billboard, you're assessing the billboard.
Thank you. I still disagree with you, but thank you for your answer. Nothing else, Chief.
Okay, Justice Dougherty.
Quick question. If the taxing authority cannot tax the rental income in its assessment, then how do you suppose that the subject property would be assessed for its actual value?
Well, it would be assessed. Actual value would have to be the actual value, excluding those things that the General Assembly has directed be excluded. So you would need an appraiser, an assessor, and they would value the property according to its fair market value, but backing out any consideration of its value having a billboard or a billboard structure on it. That would be a subject for expert testimony in the trial court. We're not at the valuation stage here, but that's something that the trial court would determine based upon expert testimony.
Thanks.
Justice Wecht.
Thank you, Chief Justice. Good morning, Mr. Byer. It's great to see you looking so healthy.
Thank you, Justice Wecht.
I wonder if your argument is sort of a little bit like pay no attention to that man behind the curtain. So we have this parcel of land. Suppose we have a parcel of land that for 75 years has been used for nothing but a billboard. It would have no value at all without the billboard. And the ground rents, rather, that the billboard can generate. How can it be consistent with an economic reality that we would ask an appraising entity to try to figure out what that property would fetch in the market in a world where there was never going to be a billboard on that property? In other words, isn't your argument wholly inconsistent with economic reality, with how the market works with the real world? Isn't it fictional?
Well, Your Honor, first of all, it's the General Assembly who has set the rule of decision in this case. This is not something the court would be doing, and it's not something that we're arguing as a landowner just to create something new. This was the General Assembly's construct, and the debates that we've quoted in our brief show that the General Assembly was cognizant of this issue. The economic reality test that Your Honor is referring to comes out of cases like Tech 1 and the Marple case. And essentially, again, that's economic reality is viewed in the context of what the General Assembly has said is taxable. This statute has to be read as a whole. 8811 read with respect to 8842, which authorizes three different methods of appraisal or assessment. In addition, the subsections of 8811 have to be read in paramateria with each other. And so in 8811B5, for example, the General Assembly has said when it is you can take the rentals, the payments into account involving a ground lease for a wind turbine or a wind generator. That has meaning that the General Assembly said that under one section and not under another subsection of the same statute. You have to read this as a whole, as the court in Snyder Brothers said. And the reality is the reality that the General Assembly has created. That's the rule they've announced. If someone has a quibble with that rule, it has to go to the General Assembly.
Thank you.
Justice Mundy.
I'm curious if the facts of the specific leases, if they exist, to the extent they exist, implicate the position on this matter. For example, I think there's signs that are by lease, and I think there may be signs that are in existence by easement. And it occurred to me that perhaps some of these signs specify that the lease is for the purpose of the sign structure versus a typical ground rent scenario where you're renting the earth that's where the sign is placed. And if you could just briefly address that and tell me whether I'm crazy or whether that might have some bearing.
You are not crazy, Your Honor. but the question,
Good answer.
but the question of whether it has any bearing, relates to the procedural posture of these cases. There are 26 cases that were consolidated in the trial court, and Judge Burr dealt with what he considered to be the overarching legal issue affecting all the cases. Can you take this into account under any circumstance? Now, the circumstances of these 26 cases, as Your Honor has indicated, vary. In some of these cases, for example, the billboard company owns the land itself in fee and has a billboard on its own property. In some of these cases, there's an easement. In some of these cases, it's a rental or a ground lease. And what Judge Burr held, and what we believe is to be a correct reading of the statute, is none of those situations really matter. In all those situations, when you're doing the assessment, you have to do it without regard to the presence or the potential presence of a sign or sign structure. Once you get into valuation based upon that, you've entered the area that the General Assembly has directed be excluded. So we don't see where that would make a difference in terms of how this court would approach the legal issue. The issue is what can be taxed and what cannot be taxed under Section 8811.
Thank you.
Thank you, Justice Bear.
Good morning, Mr. Breyer.
Good morning.
In the situation you just described, where a billboard company owns in fee the real property, is that real property taxable at some fair market value?
Land would be taxable. You would have to come up with a value, whether it's using comparable sales or if the property could be used for any other income-producing purpose other than a sign. But there would be a way that the land could be assessed, and we're not contending otherwise.
If I own a piece of farm property, which is adjacent to the Pennsylvania, beside the Pennsylvania Turnpike, and it's worth $100,000. That's its value. Now a sign company approaches me, be it through rental or otherwise, puts 3 billboards on there. And I know this is not your case. I'm just working by analogy.
Sure.
And does that make my real property go from $100,000 to $200,000, just in terms of the value because the signs are there? Is that a permissible increase in value?
If the value is increased because of the signs, the assessment would have to be based on the value without regard to the signs.
Okay, so my property would remain worth $100,000, even though I could sell it for $200,000 from somebody who wanted to buy my property and the signs.
And that's the difference between a sales price and an assessed value. And the assessed value has to be pursuant to legislative rules. And there is often a differential, just as there is, again, a differential in jurisdictions that we're familiar with, for example, Allegheny, or the city of Pittsburgh, or Philadelphia, where you see a separate valuation for land and structures. And here, under the school district's argument, the land would be worth the same whether it's vacant or has a structure on it. That can't be the case. The only reason that the land is being increased by the income is because you're valuing the actual or the potential structure. And so that's where we say that this case is squarely controlled by the text of the statute.
Thank you, Chief.
Thank you, Justice Todd.
Chief Justice, I have no questions.
Thank you, Mr. Byer. If you had a line or two of summation, we'd appreciate it, and then we'll hear from the appellees.
Thank you, Mr. Chief Justice. In conclusion, the court must consider whether the General Assembly, in enacting Section 8811B4, excluding signs and sign structures, nevertheless intended that income from the excluded signs and sign structures would be considered in making a real estate assessment. For a host of reasons, that simply does not make sense in light of the text of the statute and its obvious purpose. The school district's arguments related to the income from the billboards effectively would convert a real estate tax assessment into a tax on revenue or income. Of course, that also would be contrary to law. Instead, the real estate here, land, must be assessed as if the land were vacant, or at least not as land on which a billboard is included. For these reasons, we request that the Commonwealth Court decision be reversed and this court remand the case to the trial court for further proceedings. Thank you.
Thank you. Okay, we have two appellee school districts, and I understand that the respective counsel would each like to make a brief argument employing the that we've allowed. So I think, Mr. Weiss, are you going to say first?
Yes, I go first, Your Honor. Good morning, Mr. Chief Justice and the Honorable Justices. If the court please, my name is Donald J. Weiss, and I'm here on behalf of the school districts of Chichester and a school district, Chester-Upland School District. I'd like to reserve 7 minutes for my co-counsel to argue the issues of uniformity and constitutionality. I heard Mr. Byer's argument, and I don't read the statute the way he does. The way I read statute 8811B4 is that it says no sign or sign structure, even if it's affixed to the ground, should be taxed. Now, the way I look at that is a billboard can range in cost anywhere from $50,000 to $250,000. So I interpreted that initially to say I can't tax the sign, even though it's affixed to the ground. And most billboards really do become fixtures because they do become permanently affixed to the ground. They're not easy to move. So I'd like to just direct your attention to Judge Collins' opinion on page 13 of his opinion, where he says, the doctrine of strict construction of a statute in favor of the parties applies only where there is a reasonable doubt regarding the meaning of the provision. Here, there is no doubt that section 8811B4 applies only to exclude the valuation of an advertising sign or its sign structure and does not prohibit the valuation of land according to the CCAL and applicable case law. Now, Mr. Byer, and I think Justice Mundy asked, of these 26, and there are going to be more, we have a combination of leases, which are generally triple net leases. A triple net lease requires the lessee to pay all the taxes. We have easements where the billboard company bought the easement and the owner continues to operate a business there. And we have properties where the billboard actually bought the ground. If you follow the lower court's decision, I have a recent case specifically in Chester City where a billboard company bought a vacant piece of ground for $240,000. Then they erected a billboard on it. If you follow the lower court's decision and opinion, when they buy the property should be assessed at $240,000. When they erect a billboard on it, then it should go to zero. because according to the lower court's decision, once a billboard's put on it, it should have no assessment. And if you follow the Buell Foundation case, and even going back to the Whitcomb case, you have to value property based upon the best use that it can be applied to at that time. So if the best use is a billboard, then it should be valued based upon what it can be done. So I think Justice Baer asked the question, suppose you own a piece of ground and it's only worth $100,000, but then a billboard company comes along and buys it to put a billboard on it, and it goes to $200,000. Well, in my opinion, then it's worth $200,000, and that's what it should be assessed for. There are certain situations where the billboard company actually bought a piece of ground to prevent the owner from erecting a billboard because they did not want another billboard right next to their existing billboard.
Thank you, Mr. Weiss. Justice Donahue, do you have a question?
I do not. Thank you, Chief.
Justice Doherty? Justice Doherty, do you have any questions?
No, you got that. No, I don't, sir.
Justice Webb?
Thank you, Chief Justice. Good morning, counsel. Following up, sir, on Mr. Byers' argument about the wind turbine provision. Given what the legislators did there with income capitalization method, would you agree as a general matter that the General Assembly could, in effect, dictate what the economic reality is going to be defined as for particular kinds of property, such that what we normally would think of as market value would be, in effect, disregarded or obscured with respect to valuation of a particular kind of property?
Well, I think they could, and I think they could try. I think it would be lack of uniformity. So I think it would be unconstitutional. But I certainly do think they could make a definition like they did in the wind turbine case, but in the wind turbine exception. But there's a specific example. They carved out wind turbines as a specific way to value it, whereas signs and billboards, they didn't, which to me means they had left open the opportunity to value it all three ways: comparable sales, an income approach, and cost. Well, in this situation, you'd never use cost anyway.
Thank you, sir.
Justice Baer?
Mr. Weiss, let's. You did your hypo premised on mine, but let me come back to your hypo. The billboard company, and frankly, I think it's a little bit of a red herring that it's a billboard company, pays $240,000 for the lot. Then they put a billboard on it. And your suggestion is that the value goes to zero. My suggestion would be the value doesn't go, assuming it's a $100,000 billboard, from $240,000 to $340,000. But it remains $240,000 because that's what the willing buyer paid the willing seller in the open market. Now, what am I missing?
You're right on point, Your Honor. That's what I agree. I agree with that. I said that the lower court, if you follow the lower court's decision, they would say once you put a billboard on it, it then should be assessed at zero because that's what was interpreted, his interpretation of the exception. No, I agree with you exactly. It should only be $240,000, and even though billboard might increase the value by another $100,000, I'm not allowed to tax the sign and the sign structure, but I am allowed to tax the ground.
All right, so right. All right, so let's try something else. I know I have limited time. I own a barn. I don't know why this came into my mind, okay? And my barn's worth $50,000. It's been there 100 years. Male pouch tobacco. I don't know if they're still in business, but I remember from my youth that it's on the side of every barn. So they put that sign on the side of the barn. Does that change the value of my barn?
It could, Your Honor, if the bar owner is renting the side, then the income that the property owner, owner is then getting more rent for his particular property. So if he rents the side of his building for whatever purpose, an advertisement, he gets $100 a month more, then that should go into what he's putting in his pocket every month in rent, and therefore it could increase the value.
And if the barn owner, last question, gets annoyed at male pouch and paints it white again, then you have to reassess downward?
No, then you have a highest and best use, because then the highest and best use would be for him to rent it if he can rent it. So therefore, it would be a question for the appraiser to determine if he can rent it. He at least is imputed with the income that he would get from that rental.
Thank you very much. Interesting case. Appreciate your answers.
Thank you. I inadvertently passed over Justice Mundy, so I'll ask her if she has any questions.
No, thank you, Chief.
And I apologize also. I should have known that.
No, that was my fault. Justice Todd.
Thank you, Chief Justice. In follow-up to Justice Baer's question, and now that we're in the subject of barns, and I think you said barn, not bar, Justice Baer.
I did say barn.
Oh, I'm sorry, Your Honor. I thought you said bar.
It's okay.
So obviously we know there are many mail pouch signs painted on barns throughout the country, and I assume they still do that. I still see them. Does that mean, under your analysis, sir, that any barn with a side facing a major highway is going to be subject to this analysis, that, gee, if they wanted to, their value could be increased by renting it to...
It could be, Your Honor, because remember under, I can't remember what case it says, you have to look at whether it's possible, economically feasible, legal. So if a barn owner or a building owner, we run into it in Philadelphia or in even the suburbs of Philadelphia, where people can paint things on the side of their building and lease it out. But if legally it could be done, you need to include that income in the income approach to determine the value of the property. So in my opinion, if it's legal and feasible and can be done, then it needs to be taken into consideration.
So if I'm a farmer who owns such a barn, and I would find it despicable to ruin the beauty of my barn by painting a sign on it, why should I, as a farmer, have to incur that burden of additional taxation?
Well, that's true, Your Honor, except suppose I have a vacant piece of ground that could be built for a CVS or a Wawa, and I don't want to. I just want to leave it as a piece of ground. It should be valued as if Wawa or CVS would want to come along and build a building there. So I shouldn't be allowed to say, oh, I don't want to build a building there, and therefore only have it assessed at $5,000 when Wawa might come along and pay $1 million for it. So I understand that it sounds despicable, but it's still, it's not what I say, it's what the law says.
I didn't say that the application would generally be despicable, just to clarify. My hypothetical was that I, as a farmer, might find it despicable to paint my beautiful barn.
Yes, and I might, if I had a piece of ground, I might find putting a CVS there despicable too, Your Honor. That's.
Thank you.
Thank you. We'll hear from your co-counsel now, who reserved a brief period.
Good morning, Chief Justice and Justices of the Supreme Court. May it please the Court. I didn't think I had time for an opening, but basically hearing Attorney Byer's argument and hearing the justices speak in their questioning, I think the justices have it right. What we have here, what the taxpayers are seeking and what the trial court's order does is it treats similarly situated taxpayers, either owners of income-producing property or owners of lands, lots of ground and ground rents, differently based solely upon the identity and classification of the tenant, or in, forgive me, I forget which justice said, whether the owner of the property is a billboard owner. And that violates our uniformity clause of the Pennsylvania Constitution, and it violates the Equal Protection Clause, which the uniformity clause incorporates, of course, into our Pennsylvania Constitution. What I did want to point out is that Section 8811A1 expressly includes as taxable real estate lands, lots of ground, and ground rents. And so what we have here is the taxpayers in their argument are requesting a subclassification to ignore ground rents when the tenant, a third-party commercial tenant, is a billboard owner. And that violates the economic realities of the subject properties here, and it violates the uniformity in the classification, subclassification, if you will, in Valley Forge Towers.
Thank you. With that, what's that? Well, let me ask this, since every justice has had a question, and I take the argument to be very similar to that of Mr. Weiss. I will ask if any justice has a question, starting with Justice Donahue and going down the Justice Doherty, Justice White, Mundy, Justice Barrett, Todd. Anyone?
No.
Chief, no, go ahead, Chris. Go ahead, Justice Donahue.
Chief, thank you, but I don't have any question. Thank you.
Okay, well, hearing none, then.
Chief, may I ask one question? It's Justice Barrett. I want to make sure that I'm not understanding the argument entirely. Is it your position that 8811B4 is unconstitutional because it accepts out something in the uniformity clause, or that the application proposed by the appellants is unconstitutional?
Your Honor, we are not saying the 8811B4 is unconstitutional. What we are saying is the application of the trial court's order is unconstitutional because it treats similarly situated taxpayers differently. What the exception does is it excludes signs and sign structure as taxable real estate. It does not exclude.
Why can't the legislature can do that, right?
Yes, the General Assembly has the authority to say what is taxable and what is not.
Tell me in one sentence, if you would, how is the application unconstitutional, which is the essence of what you're arguing?
The application is unconstitutional because what it says is taxable real estate, ground rents, lots of land is taxable real estate. So if I'm a property owner and I lease my land, which is income producing land, to a farmer, the farmer pays the same rent, $100 a month. That ground rent would be included in the assessment of fair market value. If I was a property owner, on the other hand, who leased my property to a billboard owner at the same $100 a month rent, that ground rent, which is normally taxable real estate under 8811 A2 and also Tech One Associates, then that would not be included in the assessment. So then we would have unfair tax burdens on the same class of property owners.
I got it. Thank you so much, Chief. Thank you. I just wanted to make sure I understood the argument.
Thank you, Your Honors.
Yeah, with that, thanks to both counsel. With that, we'll recess until 12:30.
Thank you.